Oh. Good morning. We're going to go ahead and start this December 19th, 2014. No, 2024. I wish. Meeting, and this is our meeting notice and agenda for this day. Happy holidays, everybody. Can everybody hear me down south? Good to go? All right. Okay, with that, then we'll go ahead and call this meeting to order.
Vice Chair Durrett. Do we know if Vice Chair Durrett's on remotely yet?
She has not joined yet.
Not joined yet. Okay. Please mark her present when she gets here. Justice Douglas.
Present.
Member Merritt.
Present.
Dr. Mazarana.
Present.
Chair Guzman Freilich.
Present.
Chair, we have a quorum.
Thank you. And with that, we'll go to our first public comment. We'll start in the south, open it up to public comment, then we'll go to the north, and then we will go online, and we'll tell you how to join public comment online.
To provide public comment via telephone, call 669-444-9171. Enter webinar ID 838-9736-6061, followed by passcode 640748.
Do we have any public comment down in the south?
Doesn't look like it.
Okay, public comment in the north? No public comment. Okay, what about online?
If you wish to provide public comment, dial *9 to raise your hand if joining by phone, or click the raise hand icon if joining via Zoom. There's no comment online.
Okay, thank you. With that, we'll go to item number 2, which is the consent agenda. We've got 2 items under the consent agenda. Item A is the consideration of approval to extend final inspection deadline to December 1, 2025. We have 10 items under that. If anybody wants to pull any of the items and handle that individually, this would be the time to do so. Otherwise, I'll entertain a motion to approve item A 1 through 10. And then agenda item B is the meeting minutes for our last meeting, which was November 21st, 2024.
Member Merritt, I move to approve the consent agenda, item A, in consideration of the 10 items, and item B, the minute meetings from November 21st, 2024.
Member Mazarana seconds that.
Thank you both. We have a motion in a second. Do we have any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Motion carries. Thank you so much for that. And we'll go on to agenda item number 3, which is the approval and resolutions. Chief Gilbert.
Thank you, Chair, and good morning to you and members of the board. Steve Gilbert for the record. Agenda item 3A is an informational item presented as a notice to the board of an establishment that has been issued their final license since the last board meeting. Item number 1 is for Essence Henderson LLC, which applied for and was granted a conditional adult use retail store license in December of 2018 by the Nevada Department of Taxation under the ID number RD348 within the Carson City jurisdiction. On November 12th, 2024, the CCB conducted a pre-opening inspection and audit of the facility. The inspection and audit result revealed the facility was in compliance with the NCCRs and NRS. A statement of no deficiency was issued on November 13th, 2024, indicating Essence met the regulatory operational requirements to become operational. The CCB approved and issued final licensure to Essence Adult Use Retail Store on November 19th, 2024. I'll turn it back to you.
Thank you. This was a discussion only item. And with that, we'll go ahead and unless anybody has any discussion for that item, we'll go on to item number 4. Okay, with that, we'll go on to item number 4. This is a consideration of cultivation service agreements. Chief Staley.
Chair Guzman-Freilich, Vice Chair Durrett, Justice Douglas, Member Merritt, and Dr. Mazarana. For the record, I am David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 4, which consists of 1 cultivation service agreement. Item A is a cultivation services agreement between Healthcare Option for Patient Enterprises, LLC, and Southern Nevada Growers, LLC. Both Hope and SNG are current cannabis licensees, and the agreement provides for SNG to provide its cultivation expertise and manage Hope's cultivation operations. In return, Hope will sell all of its cultivation product to SNG at prices set by the agreement. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Dr. Howard Rubin and Stephen Spielman are present today to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you, Chief Staley. Welcome and happy holidays to you.
Thank you.
This appears to be a pretty simple services agreement between the two entities. Are there any additional comments that you might have or any questions? And then we'll go to the board for any questions they might have.
For the record, I'm Dr. Howard Rubin, one of the owners and managing members of Healthcare Options for Patients Enterprises. The acronym is HOPE, and we operate under a DBA as HOPE. I have no questions. I'm here to answer if you have any.
Okay, thank you so much.
Good morning. For the record, Derek Connor with the law firm of Connor & Connor, appearing on behalf of our client, Southern Nevada Growers. Also with us is Mr. Stephen Spielman, appearing via Zoom. We just want to thank the CCB staff for getting to this and reviewing it very quickly. So thank you very much to Mr. Staley and Ms. Dana Lauren. And I will be here to answer any questions that the board may have for us.
Thank you so much. Is Mr. Spielman on as well? I know you mentioned he's on, I just don't see him on the screen. Just for the board so that they know whether or not he's on for any questions they might have.
Just for the record, he texted me this morning and said he was on Zoom, but I think I assume he's muted.
Okay. Do we have any questions from board members?
Member Douglas, I have no questions. I would make a motion for approval if no other member has questions.
Doesn't appear like there are any other questions, so I will entertain that motion. Thank you.
Member Mazarana seconds that motion.
Was that a motion for approval?
Yes, ma'am.
Okay, we have a first and a second. Any discussion on the motion? Hearing none, and we'll put on the record that Member Durrett has joined us and for the vote. No discussion. All those in favor say aye. Aye. Any opposed? Great, motion carries. Thank you so much. Good luck.
Thank you very much, and happy holidays to all of you.
Thank you.
Thank you. You as well.
Coming.
Okay, with that, we'll go ahead and go to item 5. Item 5 is the consideration of approval for a conditional license for Cannabis Consumption Lounge. Chief Staley.
Chair Guzman-Freilich, members of the board, for the record, I'm David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 5, which consists of 1 request for approval of a conditional license for a cannabis consumption lounge. If this board approves a conditional licensure, the applicant will still need to complete necessary local approvals and a final inspection by the CCB's Inspection and Audit Division before it can open for business. Item A is a request for approval from the Limo Joint LLC for an independent consumption lounge under application number ACON-A22-00034. Limo Joint has submitted all information required to move to a conditional license status. Areas of concern were developed with this application regarding the following. Andrew Januso, the controlling shareholder of Limo Joint, also owns a company called Trade Ready LLC. Trade Ready operated a website which sold Delta 8 and Delta 9 products in excess of 0.3% THC. CCB staff sent Januso and Trade Ready a cease and desist letter on February 22nd, 2024, and the company notified the CCB that it had ceased ordering and selling such products. Trade Ready, through another of its websites, sold 34 items that the Florida Department of Agriculture and Consumer Service of Food Safety found were unsuitable for human consumption due to the presence of heavy metals. Trade Ready was issued a cease and desist letter from Flora Research Laboratories LLC after Flora discovered falsified Flora certificates of analysis on Trade Ready's website. On April 12, 2016, the Nevada Division of Public and Behavioral Health issued a warning regarding medical marijuana tours, which explicitly named Januso's company 420 Tours Las Vegas website, which was incorrectly implying that a doctor's recommendation and ID were the only requirements needed to legally purchase cannabis in Nevada. The notice included that any dispensary that sold medical marijuana to such tour businesses as 420 Tours Las Vegas would not be in compliance with Nevada law. The United States Internal Revenue Service issued an IRSA tax warrant on June 23, 2023, issued against Januso for $89,703 in unpaid federal taxes. And lastly, the $200,000 liquid fund requirements outlined in NCCR 5.045 2A2 for a consumption lounge was financed through Trade Ready's 2022 profits, which included the sale of illegal Delta 8 and Delta 9 products, and potentially with products containing illegal amounts of heavy metal. Regulation 5, paragraph 3, provides in part that an application for a cannabis establishment license is a request to the board for a decision upon the applicant's general suitability and integrity. In addition, Regulation 5.100, paragraph 1, provides various grounds for the board to deny an application for licensure, including violation by the applicants of any of the provisions of the NCCR or Title 56 of the NRS. I am available for any questions, and my understanding is that Amanda Connor, Andrew Januso, Jacqueline Ibarra, Isabel Ibarra, and Albert Mastro are available to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you very much. Welcome.
Good morning, Chairwoman, members of the board. Amanda Connor with the law firm of Connor & Connor. Today on behalf of the Limo Joint. With me up here, I have Andrew Januso, and also we have today Al Mastro, Jacqueline Ibarra, and Isabel Ibarra here. We appreciate the work that Chief Staley and his staff did in the investigation. We know he listed in his report just now to you areas of concern. The Limo Joint has provided written responses to each of those, and it is our understanding that you guys were provided with those for review. So instead of going through those in detail, I will open it up in just a moment. We can address any questions or concerns you may have with regards to those. But what I would like to say is that over 2 years ago, this group came together very excited about the prospect of opening an independent consumption lounge. They formed a group. At the time, they had identified a location. Unfortunately, since that time, the location has fallen through, so they have to adjust their business plan, assuming approval today, to tailor to a new location, but they have all the tools and the right people to do so with experience and in different areas. They would form a good business to move forward. We do understand the concerns that the investigator had, but again, we did provide written responses to those and would be happy to address any questions you may have.
Ms. Connor, I did read your response to that, and I think I can boil it down to your response was that the limo joint has yet to be licensed, and so that it has not violated any rules because it's not, in essence, it hasn't been licensed yet. My concern, and we can take each of these concerns that staff has brought to us, we can take them one by one, but I have a lot of concern, and hopefully you'll be able to, by the end of this item, ease our concern, or at least my concern, because I'm only speaking for myself right now, because our job here is to find the licensee, the applicant suitable. And just with the information that I have here, this is like the poster child of unsuitable. So I'm hoping that you're able to convince us otherwise. And that's just from where I sit right now. We have licensees who are suitable and they've gone through the process. And so we need to make sure that Mr. And I'm sorry, Mr. Januso is suitable because he is a 90% owner of this operation. He's not just a passive owner or an owner that has a small stake in this. He is basically the operation. So with that, I'll go ahead and open it up to the rest of the board members, questions or concerns that they might have.
Member Drett, I think this is interesting because it's an opportunity for somebody who's operated outside of the legal market to participate in the legal market and see if that helps, shine a light on the activity so that he goes legal, I guess. But another kind of interesting, weird thing about it is that if it was an actual felony for conducting this activities, we would have a process to waive that. So he's kind of stuck in this area where he was doing these illegal activities, but he wasn't caught for it and got a felony. So I don't know how he really could go forward. But I do have a lot of reservations with the chair. This is, like she said, I think actually part of the big problem too is that the response is, well, I haven't been licensed yet, so I didn't do anything wrong. Well, staff asked you to address these areas where the operations were outside of the law. So then the response avoided responding to those. So I think that's a big problem.
And this is Amanda Connor for the record. We submitted, I believe, 5 different letters and specifically addressed. So it raises concerns to me if you got all of our responses, if you're summarizing the response as that the response is, well, the limo joint is not yet licensed. I will say that with regards to the issue with heavy metals in certain products in Florida, which is not hemp, not cannabis, it was related to mushrooms. The response was that there wasn't testing standards and there's different understanding there, and Florida applied the hemp restrictions to that product. And yet our response was, but with limo joint, Nevada clearly does have testing standards, COAs, requirements that would be for the products that they would have to follow. But never, I would not summarize our responses across multiple letters to be the limo joint isn't yet licensed and therefore there's no explanation. For the taxes, we provided proof that the taxes have been paid and satisfied and an explanation for that. For the 420 tours, there was a whole letter that explained what had happened in the process for that. So with each area of concern, there was more of a response than just the limo joint isn't yet licensed. And we're happy to address questions and go through each of those, but I do want to make clear that that is not our position. Our position is not, well, those things happened in the past, but this one is, the company's not yet licensed. we did provide explanations as to each area of concern.
Chair Guzman-Freilich, this is David Staley for the record. I will note the investigative report included as exhibits each of those responses in their entirety. Ms. Connor, all of your responses were available for board review in their original form.
Member Direct, I do just want to also make it clear. Yeah, I do see I have seen the other letters, like the tax one. I did see it was a separate one. I appreciate that explanation that the spirit of the letter I'm referring to maybe was just was different than the way I took it.
And so maybe we could take those items, in particular, the hemp products that were in excess of legal THC limit. And we have proof of that because staff did order the items and have them tested. And the falsification of the certificate analysis and the fraudulent medical letters, those are the main three that I'm concerned about. So if we could, unless the other board members have concern about the other items and want to hear about that, if we can focus on those three, at least for my edification.
Yes, so Amanda Connor for the record, with regards to the hemp products sold by Trade Ready through Silomart's website, the cease and desist was received in February of 2024, and a response was provided to that the products had been sold out and they ceased ordering and distribution of those types of products. And since then, and Mr. Januso can provide more information if you need, but since then, that website is no longer, or Trade Ready is no longer under his control. He sold that. He got out of that business completely, looking forward to the opportunity of running a consumption lounge licensed in the United States or in the state of Nevada. He understands the concern. He acted promptly when he received the cease and desist. And like I said, sold that website, which we provided information to the investigator about that.
Okay. Any questions with regard to the issue of the hemp products?
I believe that was the cease and desist that I was just responding to, unless you're referring to a different hemp product, if you could clarify.
No, that is it. I just wanted to hear from you or your client with regard to whether or not he was still interested in that business, and if he had any interest in that business still, and if they were still selling hemp products with above the legal limit of THC.
So I believe I mentioned in my prior response, he sold that website and is not involved in that anymore. I'll let him speak to if he's still interested in the hemp business, perhaps getting back into it, I think is maybe your question, but he is not, he has sold out of that website. So whatever that website is doing is no longer under his control.
Okay. With regard to the falsification of certificates of analysis, can you please explain how that happened, why it happened?
So it is in our written response. To Mr. Januso's knowledge, Trade Ready and specifically himself did not alter any certificates of analysis. He is aware of allegations of doing so, and that there was people that use software to create or alter certificates of analysis. But he does not, he can confirm he did not do any such activity. and that he trade ready when he was running it, relied on qualified laboratories and their test results to do so. But again, trade ready is no longer under his control.
Mr. Januso, were you aware that these, of these falsified certificate of analysis?
For the record, Andrew Januso, thank you for having me here today. I was not aware of it, but when someone purchases a product off a website, we provide them with a certificate of analysis. What they choose to do with it after that is kind of in their own control. For example, if someone were to buy, mushroom products, we provide them with a COA that shows that the mushrooms are, meeting the clean requirements. It would take nothing for someone to photocopy that, upload it onto Photoshop, change whatever they want without my knowledge. And I believe, I'm actually very confident that's exactly what happened. Unfortunately, we live in an era where Reddit and all these forums and everything is so much more prevalent, where it takes nothing for someone to make false allegations. Specific to those COAs, it goes back to December 27th, 2022, where someone actually made a post saying that Trade Ready, or one of its websites, was falsifying COAs. We actually received a call from Flora Research. I explained the situation to them. They immediately took down their notification that was on their website, and then also the Reddit post happened to be taken down as well. So obviously there was someone trying to, find some way to hurt our business, and it obviously didn't work out.
Okay. Any questions from the board members with regard to this item? With regard to the falsification of the certificate of analysis? Okay. Any additional comments with regard to that item? Okay, with that, then could you please talk to me and just explain to me what happened with the fraudulent medical letters? How did that come about? When did you find out about them? Who was responsible for that?
So, I believe with that question, you're talking about 420 tours and the medical card, California cards issued back in 2017, 2016. Is that correct? Is that the question?
Yes, that's correct.
So 420 tours was licensed by the city of Las Vegas. And that's where these come from, is from a report, an investigation based on concerns and reports that the city of Las Vegas engaged in. The setup that 420 Tours had, and Mr. Januso can provide more insight, was that they had a doctor, and it was done through telemedicine to get a California medical card, which was a permissible process through the state of California. And it's not an actual card, it was a letter of recommendation, which is what California law permits. So they had set up that business operation. They were licensed by the city of Las Vegas. They were acting in good faith, using telemedicine for a doctor to get a California medical recommendation. They were understanding, based on their licenses and their understanding, that they were operating a legal business. They did, once they got notice from the city of Las Vegas, they complied with that. They ceased those operations and business activities. They appealed their thing, the determination of the city of Las Vegas. But once they got the final determination, they just did not pursue those business ventures in the city of Las Vegas.
Okay, any additional comments to that explanation?
We're happy to provide more detail if the board has more questions.
Any follow-up questions with regard to this item by the board members?
Member Douglas, for the record. I have the concerns that have been voiced by other members of the board. This is up to date for conditional license, not an actual license. I think if these concerns are not answered in a more forthright way, I would vote for denial for final license. But having said that, you said earlier that your site had fallen through. Where are you at finding another site and so on with this business?
For the record, Andrew Januso, we have identified a couple other locations outside of the tourist corridor. And hopefully if we were to receive a conditional, we can move forward with those.
Is your financing in place at this point to go forward and projected plan and so on laid out?
Yes, it is. That has not changed from the start. I think, the big thing for us the past few years has been going through the suitability investigation and, providing adequate responses to what staff has raised as areas of concern.
Ultimately, the concern is the businesses you've associated yourself with have been walking a very fine line as to legality and following the rules. And for us to openly welcome you really creates a problem for us in terms of your choice of partners, so to speak. That's all I have to say, Madam Chair.
Just if I could interject, I would, going off Justice Douglas' comments and previous comments by the board, I would offer that we are happy to provide additional information and responses. In working with the investigator, I don't know if you're aware, but the investigator we were working with left the department towards the end of the investigation. And when it was taken over, we were informed that they felt that there was sufficient information to move it forward to the board. But we are, my client is happy to provide additional information if that would be so requested.
Thank you, Ms. Connor. With that, are there any additional questions from the board before we move it back to the board for action?
Member Drat, I have another comment. If this does get delayed for more information, I think the approach coming back should be more of the concession that you operated outside of the regulatory framework in different businesses, but you want to now operate within the legal framework and you won't be involved in any of those activities anymore. I think you were an entrepreneur and you've done well at different businesses, and I don't think it was a lot of people in the current legal market did operate in the illegal market before. It's not like an evil sin. I just think that it needs to be very clear that you wouldn't be bringing any of those past ventures into the legal market, that we wouldn't be licensing somebody who was going to continue at least gray area, if not blatantly illegal activities.
And Vice Chair Durrett, my apologies if that did not come through in the response. I know in the interviews that was discussed for quite a while with Mr. Januso, and that we are happy to supplement or provide additional information, but that was the message he conveyed to the investigator in the interviews, that he is looking for the opportunity to come into the licensed market, and if so, he has already started taking steps, selling the Trade Ready website and doing some of that, but he would be stepping into this licensed area of cannabis.
Member Dredd, last thing, I just think, not saying either way it would go, I would want to remain open to there being a pathway to enter the legal market. For those who, this industry has more of has this other interesting issue of the war on drugs and the damage created by that. So opening up pathways to go from the illegal market to the legal market, I think it's beneficial overall. Like that has to be weighed against the weighed against concerns about suitability. Not that that is an answer either way. That's what's on my mind. So I just want to share that. Thanks.
Thank you, Member Durrett, and well said. And yes, we just have to remember these are privileged licenses, and it's a tough market. But we do our job is to vet the applicant and make sure that they are suitable to do business in Nevada, because we want to have that gold standard in regulation. And so I know that you can appreciate our concerns, and with that, I'll just bring it back to the board and look for a motion on this application.
Yeah.
For the record, Andrew, so I just want to state, throughout my whole entrepreneurial career, I've always carried business licenses in unincorporated Clark County and also City of Las Vegas. I also received a privileged license in the City of Las Vegas. So I do find myself suitable. I just want to say it's not as bad as maybe it really is. The businesses are legal that I've been in. Hemp is legal. Functional mushrooms are legal. They're sold on Amazon. So, I understand the area's concern, but again, I feel we have provided adequate responses to them. And I just hope you give us the opportunity to prove to you that I am a suitable licensee for an independent cannabis consumption allowance license.
I appreciate your comments. Thank you. Any additional questions? And if not, we'll bring it back to the board for a vote. With that, I'm prepared for a motion. Is there a motion from the board members?
Member Durrett, would other board members feel comfortable if I made a motion to bring this back after we have the ability to ask a few more questions?
Ask more questions right now?
No, bring it back on another agenda item, hopefully soon, so we don't delay it forever, but bring it back on at another meeting after we have the opportunity to ask staff some more questions, and probably staff ask some more questions to clarify some more of the issues.
Are there any questions that Mr. Staley would be able to answer right now that may not have been in the materials that are subject to public information? Or I'm just trying to use this time, since we're all here, and to the extent that we can, to be able to just vet out the issues. And if this item fails for a lack of a motion, then be it. But if we can, for right now, if there's any additional questions that can be answered, we can use this time wisely to do that, since we have everybody at the table.
I am Amanda Connor, for the record. We are happy to ask more questions or answer more questions if the board has, but we also, my client would not be opposed if the board feels that they need additional investigation, to have it deferred back to staff for additional investigation. We are happy to do that and be assigned to a new investigator and answer any more questions or go through additional suitability.
What's the pleasure of the board?
Member Douglas, for the record, I'd make a motion to defer this matter back to staff for additional investigation to clarify some of the answers that were provided and have consistency of the investigator.
Member Merritt, I'll second.
We have a first to refer back to staff. We have a second. Any discussion on the motion? Hearing none. All those in favor say aye. Aye. Any opposed? Motion carries.
Thank you very much.
Thank you. Okay, with that, we have item 5B and 6A, which are related. Those have been pulled from the agenda and will be heard at a meeting on 12/27 next week. And with that, we'll go to item 6B. Mr. Staley?
Chair Guzman Freilich, members of the board, for the record, I'm David Staley, Division Chief of Investigations for the CCB. Item 6B is a TOI application by Gravitas Nevada Limited, TOI number 2400020, was filed requesting approval for internal changes of ownership of Verdant Nevada LLC, the 40% owner of Gravitas. Gravitas has also requested a waiver of NCCR 5.110 pursuant to 5.112 for transfers of less than 5%. Staff suggests that if approved, the board limit Gravitas's 5.110 waiver to expire on its next TOI agenda date. No areas of concern were developed in connection with this investigation. I'm available for any questions, and my understanding is that Alicia Ashcraft and Barry Fieldman are available to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Thank you very much. Thank you, Ms. Ashcraft.
Good morning, Chair Guzman Freilich, Vice Chair Durrett, members of the board. Alicia Ashcraft of the law firm of Ashcraft and Barr on behalf of the applicant. With me today are Michael Thompson and Daniel Wax, who are the majority owners of Verdant, which, as Chief Staley mentioned, is the 40% owner of Gravitas. Also, as Chief Staley mentioned, this is fairly straightforward. Some members of Verdant Nevada exited the company, and there were adjustments, allocations of the membership interests to the remaining members, of which Mr. Thompson and Mr. Wax are the majority holders of those membership interests. We request approval, given that there are no areas of concern. Happy to answer any questions. Just wanted to quickly thank and acknowledge CCB investigator Erica Garcia, who I understand is a fairly new addition to the investigation staff. And then I think this was one of her first assignments. She was wonderful to work with, and we thank her for her diligent and quick processing of this application. But again, happy to answer any questions you may have.
Thank you, and we appreciate your comments. Welcome. Any questions from the board members?
Member Douglas, no questions. It's nice to have a nice clean application that we can move forward quickly.
Yes, thank you.
Member Mazzarano makes a motion to approve the Gravitas Nevada TOI 2400020.
With the request for waiver, I'm so sorry, Member Mazzarano, could you add that?
With the request for the waiver
Of NCCR 5112.
Got it, of NCCR 512.
Thank you.
Is there a second?
Member Douglas, I'd second that motion with those clarifications.
Okay, is there any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Okay, motion carries. Thank you, and thank you for your appearances.
Thank you so much. Happy holidays.
Thank you. Happy holidays to you. And that will go on to item number 7A. This is with regard to the consideration of proposed settlement agreements to resolve disciplinary actions. We have our Deputy Attorney General, Mr. Rath.
Good morning, Chair. Christopher Rath, Senior Deputy Attorney General, for the record. The settlement agreement we have up for today is the CCB versus MA and Associates, case number 2020-23. This licensee is a cannabis lab facility in Las Vegas. The CCB did not file a complaint in this matter, as the parties were able to negotiate the terms of a settlement agreement on the violations at issue. The allegations detailed in the settlement agreement arise from the CCB's investigation of a third-party complaint claiming the lab was reporting dry weight potency values instead of wet weight potency values, which is a Category 2 violation. The CCB's investigation confirmed this violation. This practice took place over 8 months and affected several thousand certificate analyses, or C of A's. The result of this practice was to show artificially high potency values on all the subject COAs and in metric. This is the sole allegation in the 2024 investigation. Notably, MA has a compliance history. They reached a settlement agreement to resolve the prior violations in 2022. In that 2022 settlement agreement, MA admitted to 1 Category 1 violation, 2 Category 2 violations, and a Category 3 violation. For this present case, as a result, the CCB could have sought revocation of MA's license for its 2nd Category 1 violation or 3rd Category 2 violation within 3 years. However, given the licensee's cooperation, the mitigating factors, the CCB waived that right and agreed to settle this matter with respondent. As set forth in proposed settlement agreement to resolve the current violation, the respondent admitted to 1 Category 2 violation for violation of NCCR 11.070, which does not allow the reporting of potency values based on dry weight. Respondent also agreed to pay civil penalties in the total of $20,000, either as a lump sum or over a 10-month payment plan. The CCB staff and counsel fully considered mitigating factors in coming to this resolution. Those are set forth in paragraph 20 of the settlement agreement, and the parties have agreed to the weighting of the mitigating factors. The mitigating factors include the fact that respondent cooperated with the CCB staff in quickly developing and implementing a plan of correction shortly after receiving notice of the violations. Also, MA hired a new scientific director and implemented measures to ensure that dry weight potency values were no longer used. And respondent and its counsel agreed to resolve this matter without a complaint hearing, thereby saving time and money for the state. Also, CCB staff and Attorney General considered the licensee's ability to pay. Given the serious violation of reporting false potency results and the licensee's compliance history, along with the payment plan, the civil penalty is extremely reasonable in this case. Respondent also provided a plan of correction, which is detailed in paragraph 30 of the settlement agreement, and the CCB staff has approved this plan. In summary, the plan of correction includes the following. Respondent corrected over 2,800 COAs and has removed the dry weight calculations from COAs. And respondent's scientific director started a periodic review of the COAs to ensure their accuracy before they go out and continues to do so. Based on those foregoing reasons, the Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for any questions, as is counsel for respondent Amanda Connor.
Thank you. Ms. Connor, unless you have any clarifications, I'll open it up to the board for any questions that they might have.
Amanda Connor, for the record, at this point, no clarifications. We are available for questions. I did want to know, I believe on Zoom is Ari Sarna, a representative of the lab if needed.
Thank you for that. With that, I'll bring it to the board for any questions that you might have. And I see your client now. Welcome.
Thank you. Good morning.
Okay, thank you for your cooperation. Any questions from board members? And if not, I'll entertain a motion.
Member Douglas, motion for approval of the settlement agreement.
We have a first. Is there a second?
Member Merritt, second.
Any discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Thank you so much.
Thank you, and happy holidays to all of you.
Holidays to you.
Happy holidays to you.
Thank you, everyone.
Thank you. Okay, with that, we're going to go on to item 7B, which are items B1, 2, 3, and 4, and those have been pulled from the agenda. So with that, we're going to then go on to item number 8. This is a petition filed pursuant to NRS 678B.633. We're going to clear the room because I believe that our petitioner has requested a closed meeting. So we'll go ahead and close the rooms in the north and the south, shut down the Zoom for the internet public
If we are back on the record, Madam Chair, I'd make a motion for approval of the request for the pursuit of a cultivation facility card limited to cultivation facility card.
Is there a second?
Member Maserano seconds that.
Okay, we have a first and a second. Any discussion on the motion? All those in favor say aye. Aye. Any opposed? Motion carries. Thank you so much and good luck.
Thank you very much. I appreciate it, and thank you for your time.
Thank you.
Good luck to you.
Thank you.
For the holidays.
Happy
You
holidays.
as well.
Okay, with that, then we'll go on to our administrative matters, our briefing from the chair and the executive director. All I have to say is happy holidays, everybody. I hope that you have a safe, healthy, and happy Christmas and New Year's, Hanukkah, and all of the above.
Excellent. Thank you, Chair. I will give a brief overview now. CCB has one agency-generated bill. So I will kind of go over this, and again, apologies if this is a little dry, but go over the general nature of what the bill does as currently, as introduced. So with that preface that as with any bill, any piece of legislation, still going through different changes, iterations, obviously hasn't even been heard yet, but we've had very productive conversations even thus far as soon as introduction with industry as well as other stakeholders. And the goal is for the agency or the agency board to continue to have all of those, or even more as we lead up with the anticipation that there being an amendment once everybody's kind of had a chance to look and review the bill. So again, just take this with knowing that this is as kind of this overview is as introduced. Again, apologies if it's a little dry. Myself and the team will, of course, work on this for our testimony if and when the bill gets heard. But again, this is just kind of as the bill was introduced. So bill numbers AB 76. As a result of recent legislation, Cannabis Compliance Board is no longer exempt from the Nevada Administrative Procedure Act or the APA, which falls under NRS 233B. Thus, this bill amends statutory language to dovetail with the requirements of the APA. Further, it streamlines the administrative process and relieves the board of responsibility for administrative housekeeping assignments by allowing the executive director to initiate complaints and assign matters to a hearing officer, shifts responsibility for issuance of subpoenas, acceptance of filings, and other administrative matters to a hearing officer, provides a hearing officer statutory authority to conduct hearings and issue a decision. Due to the evolution of the industry, including the addition of consumption lounges, it illustrates a regulatory need for quick action to notify the licensee of violation, request correction, and provide a hearing process for minor regulatory violations. This bill also includes a process for notice of violation to quickly address and provide due process for complaints of minor regulatory violation. The bill also revises existing regulations to clarify the requirements for ID scanning at cannabis sales facilities and lounges, provides additional clarification to the definition of synthetic cannabinoid, changes cultivation to acquisition, which provides clarity to the regulation insofar as correcting the relevant point to start tracking in the seed to sale tracking system. It specifies what SOPs are required by independent testing laboratories and adds that testing may be required for anything specified in regulations. Clarifies that inspection is required prior to final licensure, adds agent training and any other procedures required by regulation to the operating documents required, and creates an allowance for vending machines within a licensed establishment. Clarifies that cannabis products cannot take on certain shapes or images that may appeal to children. prohibits someone from advertising their business as a cannabis sales facility or consumption lounge unless they are properly licensed. Adds language to allow for immediate temporary cease of operations due to imminent health hazards, to be consistent with other agencies enforcing public health. Adds CCB agents and their attorneys to the exemption from prosecution for certain acts. Removes the requirement that hemp must come from a Nevada hemp grower. Removes the allowance for independent testing labs to transport cannabis to cannabis sales facilities. Revises the packaging size limits to be consistent with new possession limits and industry demands. Allows for distribution to a consumption lounge. Additionally, the bill is designed to protect the identity of a person who furnishes information to the board or any board agent. Grants authority to the board, executive director, or executive director's designee to issue a letter of warning. Amends existing regulation and provides new language to identify the meaning of public school, private school, and community facility. Refines the definition of usable cannabis. Updates NRS to allow for the smoking of cannabis or a cannabis product in a consumption lounge. Amends the existing regulations and to specify the parameters in which information, data, and application details are to be kept confidential. The amended language also provides the terms when information and data is not confidential and regulates the required process for submitting a request for disclosure of information and data. New definitions are also provided to assist with the clarity of the statute. So obviously, longer bill, lot in there, some reforms that we think are needed and necessary. But again, during the legislative process, we all know how you start is not necessarily how you finish. So again, just want to reiterate to the board, as well as anyone listening, that there may be some pieces in there that may give people pause. But we're continuing to have constructive conversations with those in the industry, key stakeholders, as well as up to my boss, and of course, outwardly to the board. So before I move on to kind of the policy and procedure of how we're going to kind of operate during session, is there any questions from the board members? And I have the whole team that helped craft this bill as well. So if we need any additional information on the specifics, we can certainly get you that info.
We have a copy of that in our email by any chance?
You do, I believe, that little bit dry testimony, unfortunately, Amber sent that last Friday, I believe. So you do have a copy of that. And again, happy to discuss in more detail if anybody wants to drill down on the actual NRS or statute. If no questions, per the chair's direction, she asked that we issue a legislative session policy. The purpose of the policy was to set clear expectations for cannabis compliance board members and agents during Nevada legislative session so that this would adhere to the board members, myself, as well as the entire team over at the CCB. The executive policy and procedures. The executive director is authorized to appear on behalf of the CCB during the legislative session and may bring subject matter experts determined as necessary. No other individual may speak on behalf of the CCB without authorization from the CCB executive director or designee. A board member may appear before the legislature on their own behalf and may identify their relationship to the CCB. However, they must specify they are not speaking on behalf of the CCB. Board members must comply with their ethical responsibilities as public officers under NRS Chapter 281A, regardless of who they are representing. Beginning in January of a legislative session, through the duration of the session, an agenda item will be added to board meetings, which will include legislative items where possible action is required, support, no support, neutral, on bills that touch matters where the CCB has jurisdiction or affects the CCB. The CCB Public Information Officer or Comms Director shall update and send bill tracking on any bill that may affect the CCB, along with news updates to the board members on a weekly basis. And the scope, the policy applies to all members and employees working under the authority of or within the CCB. Wanted to read this into the record at this particular meeting, but as it's a discussion item only, the board will also have an additional month to review this, as well as bring any additional questions forward. Based on kind of, like I said, the loose testimony that I provided on the bill as introduced. So we will actually vote on the policy at the next board meeting at the discretion of the chair. And again, we will resend both kind of my general notes as well as the policy, with the caveat that, again, as we head into session, as those discussions are ongoing, my anticipation is that the bill will have some changes to it. Happy to take any questions.
Any questions?
And before I sign off then and throw back to the chair, since I have the opportunity, it has been a year. Last Wednesday was a year. We've just done an incredible amount of work in the year that I've been here at the CCB. Let the team know last week how appreciative I am to them internally, and also just want to say that in the public forum. I think I say it every meeting, but I mean it. I got the best board in the state and the best team in the state. The CCB's team is absolutely incredible, and I am lucky to even just be a small part of it. So thank you all to the CCB team for the incredible successes we've had. Looking forward to session, looking forward to 2025, and happy holidays to everyone. And thank you, board. You're incredible. Appreciate each and every one of you, and can't wait to see what 2025 brings. Thank you, Chair.
Thank you, Director, and congratulations on a year.
Yeah, I know, right? It's
Right.
incredible.
Awesome. It went by fast.
It did.
Okay. With that, we'll go on to item 10, which is the next meeting date, which is January 16th, 2025. I believe that the new dates for 2025 have gone out. We're struggling with the place to meet. Correct?
We are
So-
working on physical location. Amber's been amazing in that regard, so we will keep everyone posted. The idea is to continue to move forward the third week of the third Thursday of every month. But if that change comes,
Scheduled meeting. Madam Chair, could you Joseph Ostrino for the record, can you clarify that that's the next scheduled meeting? Because we might have a meeting before then.
Oh, yes. I'm just reading my agenda, but we actually do, we have has it been agendized? Not
special
yet.
board meeting that will be agendized either today or tomorrow
Okay,
for 12/27.
So that will not be that will be our next agendized
Scheduled meeting.
And the next regular board meeting will be January 16th, 2025. Let's see, but yes, we'll keep everybody apprised of where we will be meeting. Hopefully we'll find a home that will be suitable for not only all of us in the north and the south, but also for the public. Items for future agendas. This is a discussion only item. If any board members have any requests for future agendas, this would be the time to request those. If none, then we'll just go on to our last public meeting starting in Las Vegas. Then we'll move up to Reno and then online. Any public comment in Las Vegas?
There is no public left in Las Vegas.
Really? What happened?
Not even our friend that's usually here.
All right, then. We'll go on to public comment in, I almost said Carson City, but it's Reno.
Reno.
There's no one here for public comment. But other than that, we'll just go ahead and.
Internet.
And the internet, thank you. Online. Do we have anybody online for public comment?
We do not have anyone online for public comment.
Wow. Okay. Great. Well, with that, happy holidays, everybody. We're adjourned.
Yeah, look at you.
So nice.